May it please your lordships.
Yes, please, Mr. Joshua.
My lords, may kindly allow me to mention item number 5, where I have to file affidavit in reply to the affidavits filed by the state respondents as well as by the private respondents.
Item 5.
Yes, lordships. I may kindly be allowed 3 weeks' time, my lords.
To file affidavit in reply to whose affidavit?
Both the affidavits filed by the private respondents as well as by the state respondents, lordship.
Okay. Mr. Joshua, the learned counsel for the petitioner submits that he may be allowed to file affidavit in reply to the affidavit in opposition filed by the state as well as by the private respondents.
Lordship.
Where is allowed, listed after 3 weeks.
Oblige your lordships.
Lordship, I'd like to mention item number 24 for hearing, Lordship.
20
24, Lordship.
years.
Lordship, here in this case, I'm representing respondent number 2 and 4, Lordship.
2 and 4.
If this matter can be taken up for hearing after 2 weeks, Lordship, I've
Okay.
taken consent
Yes,
for the opposite parties.
Mr. Muajami, the learned counsel for the respondent number 2 and 4. 6 for adjournment of 2 weeks. 6 for adjournment for 2 weeks. No. Mr. Muajami, the learned counsel for the respondent number 2 and 4. 6 adjournment of the case for 2 weeks. Prayer is allowed, listed accordingly.
Much.
Okay.
Lordships, I beg to mention item 23 of the hearing list.
23.
Wherein this matter may come up after 2 weeks
You are for?
for the appellants.
Okay.
And
Okay.
for the- Yes, Lordship.
Mr. L. Iralu, the learned counsel for the appellant. 6 adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly.
I'm obliged.
Okay.
May it please, my lord.
Yes,
I beg
please.
to mention item 3, my lord. I am to file an affidavit. However, my lord, the petitioners are unable to come till now, my lord. Yes, such kindly grant me 2 weeks, my lord.
What affidavit, Mr. Senti?
Regarding the financial payments that has been made to the contractors
Okay.
and the status of the work.
Additional affidavit.
Yes, my lord. My lord.
Mr. Senti Amar, the learned counsel for the petitioner submits that he may be allowed 2 weeks' time to file additional affidavit on behalf of the petitioner. Prayer is allowed, listed accordingly.
Obliged, my lord.
May I please, your lordships, I beg to mention item number 20 and 21. If these matters can be listed on 14th of next month.
14th. Item
Item 20 and 21.
20 and 21. You are for?
Your lordship, I'm for appellant in item 21.
And item 20? Item 20. Okay. And you are for respondent in item 20?
No, your lordship, appellant in item 21.
MS so-and-so, the learned counsel for the appellant in criminal appeal within bracket J4/2020. 6 adjournment of the case for 2 weeks.
Yes, your lord.
Prayer is allowed, listed accordingly.
Much obliged.
For motion, item number 1.
It's so hot. Put more power to the fan. Yes.
May it please your lordship, there are two IA lordship. One is filed by me and one is filed by my learned friend.
What is your
One is 30 of
30.
IA 30 of 23.
What is 30?
Then another is
What is 30?
IA 30.
What is 30?
Oh, 30 is that, Your Lordship, that we are having one building, this Jame Masjid committee, and our tenant, he has demolished the roof of the building. While there is a status quo passed by this honorable court. The fact of the case is like that, Your Lordship, that in 2010, one civil suit was filed by my learned friend, stating inter alia that he is the owner of the land, which belongs to Jame Masjid Committee. Now, Jame Masjid Committee is having a plot of land in Dag number 203, Dimapur Town, MP Road, wherein they were having a building. It was built during the time of Haji Moligul Khan, way back in 1951. And it is having a continuous CDHC roofing. Then where he is claiming his right over the land, then he filed one civil suit. Then actually he was challenging this allotment order. Then we challenged that application suit. We challenge under order 7 rule 11 that under 154, section 154 1C.
Or rejection?
Yes, Your Lordship. Under section 154 1C of Assam Land Revenue Regulation Act, that it is not maintainable before civil court. And if anything, it is to be, this grievance is to be addressed by commissioner. This is the position of law. However, Your Lordship, the honorable court,
Why commissioner?
because this Assam Land Revenue Regulation, it says that when, if there is any matter pertaining to land decided by revenue authority or revenue deputy commissioner, then the matter is to be adjudicated by the state in regards to the settlement of the land.
Whether commissioner is the appellate authority?
Actually, Nagaland Commission reduced to
No.
a revenue board. Yes, Your Lordship, revenue board. Earlier there was no revenue board, so commissioner was. Now, Your Lordship, my case is that I filed this petition, then the suit was dismissed. Against this, in 2010, the party filed one RFA, register first appeal, before this honorable court. And the matter was lingering since 2010, and it was.
Who has filed the RFA? You have filed the
No,
RFA?
no, no. RFA filed by my learned friend. Then, Your Lordship, nearly 12 years, the matter is lingering. And in between, twice the matter went dismissed in default. And finally, this honorable court was pleased to condone more than 1,000 days delay. And the matter is being placed before this honorable court. Now, while the matter was proceeding.
The RFA is pending before this court.
Yes, Your Lordship. Now, Your Lordship, while the matter is continuing before this honorable court, it was on 12/3/2023, the appellant. There was a status quo order passed by this honorable court in RFA. Now, what happened, Your Lordship? He started demolishing the roof. It was actually on 11/3. Then we saw that he was demolishing the roof. We are Masjid committee. Then we objected. Being a law-abiding citizen, we find that there might be some law and order situation. So being law-abiding citizen, Your Lordship, we went to a police station and we apprised the matter to the police by filing an FIR on 12/3 that look, such and such thing is going on and he is not listening to us, and there might be hue and cry because it belongs to Masjid. So we want to that you should interfere. Then this OC, he called the parties and he told that no, since there is a case pending before the Honorable High Court, so I will not interfere into the matter. You please maintain quiet calm and let matter be decided by the Honorable High Court. Now, in the meantime, Your Lordship, for our safety, I filed one petition, IA 30, 2023, before this Honorable Court under Order 39, Rule 1, injuncting the opposite party not to demolish further or not to undertake any further construction. Because,
Any order passed there?
yes, Your Lordship,
What was the order passed?
that injuncting the status quo to be maintained. Now, Your Lordship, Your Lordship, actually the intention of the opposite party is that it was a continuous roofing, Your Lordship. Now you want to change the structure and status of the Switzerland to show that no, it is not the part of the Jama Masjid Committee building. I am having separate. So with that intention, he has done this, Your Lordship. Now, Your Lordship, against this they have filed one IA 39 of 23 to modify the order of status quo without any provision and annexing with some cooked up and other document, Your Lordship. Now, Your Lordship, that they have also filed one affidavit in my 30. Now, they have also agreed that it was the roof is not done, and they are not coming to the point that it was demolished by them. But photograph and all this I have annexed in my petition. It will show that they are demolishing. Now, Your Lordship, in the meantime, this Honorable Court was pleased to direct Dimapur Town Committee, Dimapur Municipal Council, along with GB2, have verification of the site and give a report of the present status. Now, accordingly, Your Lordship, this Dimapur Municipal Council, this that SDO JE, she was sent along with GB of Ward number 19, and they have verified the matter and they have given the report. So, a report was given through this registry of this Honorable Court. So, I have also obtained a copy. Then, Your Lordship, today
The report has been furnished to the registry.
yes, Your Lordship,
Yes, sir.
before this Honorable Court, to file before this Honorable Court.
Something there on record.
It's on record. Which is flag? This flag X, okay.
I 30.
Now, Your Lordship, page number 1 is a forwarding letter given by this Administrator Dimapur Municipal Council. This is a forwarding letter of the report. Now, page number 2, I find that this is internal, they are noting.
You are Salikur Khan.
Yes,
Lordship,
You are Salikur Khan.
I'm the applicant, Alikur Raja Khan.
Now, Your Lordship, page 2, that it is their internal this noting, and page 3 is the verification report typed copy. My Lord, thereafter there is photograph, they have also annexed. Your Lordship will appreciate that from the photographs, it is apparent that there is no stock, there is no shelf, everything is clear inside the room. And it is not that it was fallen out automatically.
Who has dismantled your roof?
Lordship,
Who has dismantled your roof?
it was not dismantled, Lordship, it was collapsed, Lordship.
How can the roof collapse?
Lordship, it is a room of 1936, Lordship, and as submitted by my learned senior colleague, that I am the tenant of Jamia Masjid.
It
It is
is
not true
51.
because I was being given a permit by the government of Nagaland, Lordship.
So, Mr. Vikram, you are actually saying that the house is an old house and it is on the verge of collapse, but the verification report says that there is no roof in the said shop. The beam and front shutter and the walls are
Intact.
intact.
Lordship, I'll satisfy
You
Lordship.
stay without a wall. You stay without a roof.
No,
You
no,
really
no,
isn't.
no, Lordship. Actually, in the evening of 11th of March, Lordship, a small portion of the roof has collapsed, and seeing by seeing the security of my valued customers, Lordship, when I tried to mend the small portion of the roof in the next morning, that is on 12th, a major part of the roof has collapsed.
The photograph does not support your submission.
And to that effect, Lordship, they have filed one FIR with the concerned police station. And after the police has verified, they found that the FIR was totally on the pretext of cooked up stories, Lordship. And they did not find any criminal charges or criminal proceedings against me. And it was not registered, Lordship. And asked both the parties to stay quiet, Lordship. However, Lordship, with this report, Lordship, the Masjid Committee, Lordship, has tried to mislead this Honorable Court as well as the Municipal Council and even to the Gaubura, Lordship. Because it is the same Municipal Council on being verified on, Lordship, 20th of March, Lordship. They have given a certificate stating that, Lordship, it is... it is on being inspected and found that the building is in dilapidated condition which needs repairing / renovation for public safety point of view, and they have challenged that. And this Honorable Court, on being satisfied, has directed the parties, the applicant, to go for a fresh spot verification. Lordship, my sustenance is in question, and this is the only-
I find that you yourself, you have dismantled the building and you are coming before this
No, no,
court
no,
Yes,
no,
Your
as
no,
the
Lordship,
agreed
no,
person.
Lordship.
Exactly, Your Lordship.
Lordship, I'll not gain anything by dismantling my own shop, Lordship.
Just to change the status and structure, you want to show that this is not a continuous roofing
It's
of
not-
my building.
No, Lordship. I'll gain nothing out of that.
And Your
Ultimately,
Lordship,
I'm the loser, Lordship,
witnessed.
today.
This was witnessed by two of the neighbor tenant.
Lordship, those two neighbors, Lordship, one is the executive member of the Masjid Committee, and one is the tenant of the Masjid Committee. So definitely they will speak in favor of the Masjid Committee.
It is not like that, Your Lordship.
Whether the roof of the building will fall by itself.
Lordship, it is a room of 1936, Lordship. My grandfather has constructed.
No, Your Lordship. The building was constructed by us, Your Lordship, in 1951. Haji Malikul Khan.
And even in case, if actually the building, because of the dilapidated condition,
Lordship.
They should have come before the Honorable
it has
Court.
been damaged. There is a status quo order and therefore you should have
Yes.
come before this court.
Yes.
Who
Your
are
Lordship.
you? And what is your authority?
Yes, Your Lordship.
Lordship, I have not dismantled, Lordship.
Yes.
I have not dismantled, Lordship.
Then what obstructed him, Your Lordship, to come before this Honorable Court and obtain a permission for repairing and that it was And he was waiting after we filed the petition. He has come before this honorable court with cooked up and with some other documents. And he has not come with clean hand before this honorable court, your lordship, and he is not deserved to have this equity. And there are curtain of judgments of the honorable apex court that if a litigant does not come with clean hand before the honorable court, court should not give any order in favor of the litigant. Your lordship, I beg to take your lordship to my lord, if not, your lordship may constitute an inquiry by any magistrate. What was the factum was there to reveal the truth? Because he has not come clean hand before this honorable court. Just to defeat my right.
Let
Just
us see where is that status quo.
it is in his petition, your lordship. There, 39. Annexure 18. Annexure 1, your lordship. 39. IA 39, page 10, Annexure 1. Should I read, your lordship?
Yes.
17/10/2011 had Mr. P. Katania, learned counsel for the applicant, also had Mr. P. Chaudhuri, learned counsel, appears on behalf of the respondent number 1 and 5. It is stated that the appellant is in possession of the scheduled property. In the interim, it is provided that in the interest of justice, till disposal of the connected first appeal, the status quo as on today, in regard to possession of the scheduled land shall be maintained, miscased and disposed of. That was 17/10/2011, your lordship. And your lordship, his this 39 is also not maintainable, your lordship. Under what provision he can come before this honorable court to modify the status quo order? He has not cited any provision. Your lordship, I beg to take your lordship page 8, your lordship. He is 39, page 8, prayer. In the premises aforesaid, it is most humbly prayed that your lordships may be pleased to admit this application, thereby modifying the status quo order dated 17/10/2011 in the above referred appeal, thereby allowing the appellant to renovate, repair the show premises, and or may be pleased to pass such other orders as your lordships may deem fit and proper in the interest. He has demolished the room to change the status of the and structure of the building. Now he has come before this honorable court with a prayer to modify the order which was passed in 2011. Does he require equity? Does he entitled for such relief? Certainly not, Your Lordship. He has not come with clean hand. No, yes, sir. I'm going to reply. At 11. 39 reply. Reply. My lord, I have also, your lordships, I have also filed one affidavit in 39, your lordship. And your lordship, the page 7, annexure RA1, and page 8, annexure, page 9, annexure RA2. These are the affidavits shown by the tenant that they have seen while he was demolishing the structure.
We are taking up 39 today. Okay.
Yes, yes. Sir. In the last order, your lordship, this honorable court was pleased to club together with the 30 and 13. Anyway, your lordship, 13.
What is that clubbing order?
Lordship order dated 26/4/2023.
Here is it 30 maybe put together.
Now, your lordship, in my IA 30, your lordship, if you kindly peruse this page number 16, there is a photograph, your lordship, where it shows that he is that one person standing behind by a bamboo he is pulling down.
Heard, Mr. We did not. The learned counsel for the applicant and Mr. P.B. Paul, the learned counsel for the respondents. The present application, new para, has been filed, seeking for modifying the status quo order dated 17/10/2011 passed in CMC number 4K 2011 arising out of RFA number 6K 2011, and for allowing the applicant / appellant to renovate, repair the shop premises stop. On 26/4/2023, this court had directed spot verification of the building located at MP Road under the occupation of MS Linkwell. and to file report of the status of the building for consideration of the application. Stop. In terms of the order dated 26/4/2023, passed by this court. The administrator, Dimapur Municipal Council, Dimapur, Nagaland, has by the letter dated 29/5/2023 submitted the verification report. Stop. The verification report is reproduced as under. Ma'am? Verification report. It is apparent from the verification report that the site verified has no roof, that the shop verified has no roof. However, the beam, front shutter, and the walls are intact. Mr. V. Stop, new para. Mr. V. Devnath submits that. Mr. V. Devnath, the learned counsel for the applicant, submits that. The roof of the shop, the sage shop, they submits that. The yes, the shop under the occupation of MS Linkwell, being an old house, the roof of the shop collapsed. Fell, not collapsed, fell by itself. Stop. This submission of the learned counsel for the appellant has been strongly objected to by Mr. P.B. Paul, the learned counsel for the respondent, by making a submission that it was the applicant who himself has dismantled the roof to change the structure of the shop. Stop. Be that as it may. the verification report submitted by the Administrator, Dimapur Municipal Council, Dimapur, Nagaland, clearly states that there is no roof in the shop. Stop. In view of the report submitted, the applicant shall put a new roofing to the house without changing the structure of the shop. Either externally or internally, in any manner whatsoever. Stop. The construction of the roof of the shop shall be carried out in the presence of the Administrator, Dimapur Municipal Council, or his representative, and in the presence of the respondents.
Jama Masjid Committee.
And in the presence of the respondents, that is the Jama Masjid. Okay. The roof of the shop shall be constructed within a period of,
Lordship, as early as possible, Lordship, because my sustenance is in question.
pardon?
My sustenance is in question, Lordship, as early as possible, Lordship.
Shall be constructed as early as possible, but not later than 2 weeks from today.
Lordship.
The application. What is your application?
30.
39.
I-39, Lordship.
The application seeking for modifying the status quo order dated 17/10/2011 and for allowing the applicant/appellant to renovate, repair the shop premises is accordingly rejected. The application accordingly stands disposed.
Much obliged.
In 30,
It is
in view, in 30, okay? In IA 30, in view of the order passed in IA, civil number 39 of 2023, the present IA also stands disposed. IA 30, okay? Okay.
much obliged.
Much of it.
For applicant, item number 2.
Yes, Mr. Jimomi.
Your Lordships, there has been a very interesting turn-off
Okay.
in this case.
Uh-huh.
The contractor has approached the Honorable Supreme Court,
Oh,
and then certain orders have been passed.
okay.
May be allowed to place the
Yes.
orders before your lordships.
Yes.
Your Lordships, the order dated 13/3/2023 has been partially stayed, Lordship.
Okay, let us see. What was the order? What was the order? 13?
13, the order of the Honorable Supreme Court, Your Lordships, is dated 12/5/23.
No. The order passed by this court, which has been
13/3/23.
Thir-
13/3/23.
13/3.
13/3/23.
Yes.
Has Your Lordship got
We have
13/3/23?
perused the affidavit by the stated as under. Okay.
Now then, can we go to the Honorable Supreme Court's order, Your Lordships?
Yes.
This is order dated 12/5/23. Third Learned Senior Counsel appearing for the petitioner, issue notice returnable on 11/9/2023. The returnable date is in the month of September 11. Learned Senior Counsel on instruction states that the petitioner is unable to comply with clause C of the impugned order as the land has not been made over to the petitioner. In view of the statement made, there will be a stay of clause D of the order dated 13/3/23. Now, if you may turn to the order dated 13/3/23, Worships, the operative portion which begins from, we therefore pass the following orders. Have your Worships got that? We therefore pass the following orders, the operative portion. And if you
D.
yes, Your Worships.
In the statement, there will be stay of clause D.
Yes, sir.
Failure on the part.
Yes.
Failure.
Yes, failure on the part of the contractor will lead to blacklisting, etc. That has been stayed. But the basis of the stay is, Your Lordships, the clause C. And what has been submitted before the Honorable Supreme Court is that, on instruction, if you can come back to the Honorable Supreme Court's orders, Your Lordship, on instruction states that the petitioner is unable to comply with clause C of the impugned order as the land has not been made over to the petitioner.
Which portion are you reading?
The Supreme Court's order, Your Lordship,
Ah.
where the senior counsel on instruction states that the petitioner is unable to comply with clause C of the impugned order as the land has not been made over to the petitioner. In view of the statement made, there will be a stay of clause D. So both clause C and clause D have effectively been stayed, Your Lordships.
Yes.
The clause C is the deadline for the contractor to complete the work by 30th of this month.
Okay. But you will have to complete the road on the ROW. That is not stayed. B.
Accepting the last date, Lordship, about the time period given by the court. Yes, Your Lordship, according to the order of this Honorable Court, the road will have to be completed.
Huh? Only the deadline has been stayed.
Yes, Lordship.
D has been stayed, Your Lordship.
D.
So, Lordship, the work is actually under progress. We have filed a progress report also yesterday, Lordship.
Where is
this
your
Honorable
report?
Court. By the respondent number 9. It has been filed yesterday, Lordship.
Respondent 10.
9, Lordship, not 10. 10 is the authority engineer.
And where is the authority engineer? Yes, Mr. Sintianger.
I have also filed status report, my lord. That's on 29/5/2023, my lord. And the physical progress, my lord, that the contractor has achieved till now is 32.58%, my lord.
Where is that? Your affidavit dated 30. Your affidavit is R10.
Yes, my lord. My lord.
Filed today, my Lord.
Filed this morning, my lord. In paragraph 1, I have given a chart wherein I have indicated the work that they have completed, the balance work.
Where is that 32%?
In page 3,
of
my
the
lord.
affidavit. Page 3 of the affidavit. Just below the column. Physical
Okay,
progress.
completed in percentage.
Bottom of the table.
What about, what does the contractor says? Where is your affidavit? 9?
Respondent number 9, affidavit, Lordship.
9?
Lord, according to the contractor, 35% has been completed. 34.29%, Lordship.
More or less, you're on the same line.
Yes, my lord.
My lords.
The contractor, he has included the work in progress also in this calculation. I have included only that he has fully completed.
Okay. So since the Honorable Supreme Court estate will go slow,
Hands are tied, my lord.
In fact, Lordships, the blacktopping is effectively going on, but because of the weather, the progress is largely slowed down.
that is your submission since last 3 years. The weather, the publics are suffering.
If I may,
The-
if I may draw your attention again to the Honorable Supreme Court's order. So apparently the ground taken was that the land has not been made over to the contractor. So again, we are back to the issue of acquisition, Your Lordships. And this Honorable Court has directed time and time again that the state as well as the NHIDCL should proceed with steps for acquisition of the land in question. So far, nothing has been done. So that part is still alive. That part is still alive. In fact, that is the basis of the Honorable Supreme Court's order. As the land has not been made over to the petitioner.
Yes, Mr. Imti, this is where the state has to come into play.
Regarding the issue of
You know,
Your
the
Lordship,
land.
No, Your Lordship, I will be allowed to refer to the affidavit filed by the
Don't submit
NHIDC. No, Your
as
Lordship,
if you're completely.
no. Regarding this developmental work, the department or the implementing agency has to approach the state government for acquisition and requisition. So the NHIDCL affidavit is very clear. They have mentioned in the affidavit, para number 10, that they have never approached the state government in view of the Article 371A of the Constitution of India. That is the affidavit submitted by the thing.
You minus 371A.
Yeah.
I think
Yeah.
everything under the sun is not 371A.
No, I can ignore it. But Your Lordship, the thing is, it has to be approached by the concerned authority, the state government, for requisition and acquisition. That law has to be invoked and approached by the competent authority to the state government. So that's the problem now.
Only at the 11th hour, you come with some grounds. Yes, NHIDC. Have you heard what the Additional Advocate General has said?
Yes, Lordship.
Yes.
In fact, this issue has been raised on the earlier occasion also, and the same submission was forwarded at once by the Learned Additional AG Lordship. Now, NHIDCL has quite a limited role to play as far as the land acquisition is concerned, Lordship. The state and the central government has to initiate a big role on this, on the acquisition of land, Lordship. Now, the state has to hand over the land free of cost, free of any encumbrances, Lordship, to the NHIDCL. Now, I have filed my affidavit and I have enclosed 3 orders passed by this Honorable Court to go ahead with the construction of the road as per the available ROW, Lordship. In the meantime, Lordship, the state as well as the central government will take its initiative to settle the land question of land acquisition, Lordship. And since the matter has been subjudiced before the Honorable Apex Court, and this issue has also been raised, which has pointed out that due to non-availability of land, the progress of the work has been delayed, Lordship. So since it is subjudiced, the central government will be represented
Who
before
is
the Honorable
for the
Apex
central
Court,
government?
Lordship.
Who is for the
Lordship,
central
I'm
government?
also representing both the central government as well as the NHIDCL, Lordship.
So what steps you have taken with the state government to acquire the land? What steps?
Lordship, we have filed our detailed affidavit, Lordship. Now, as per the affidavit which I have filed before this Honorable Court, Lordship, as per the instruction received, Lordship, 371A has been.
Have you at least processed for acquisition of the land with the state government? Have you at least processed?
Lordship, as on date, Lordship, the letter status, if we may be allowed to file
Have you
affidavit.
processed?
No, Lordship. As per the record, Lordship, no. I cannot make submission beyond the record, Lordship. Therefore, as of now, there's no record as such, Lordship.
You are all trying to take the public for a ride. Everybody.
If I may be
Your
allowed.
blame game is actually defeating the public interest.
I may be allowed to file affidavit, Lordship, as to what has been
Affidavit will
initiated,
not
Lordship.
do. Affidavit will not do.
Lordship.
Let us see what steps you are taking with the state government to acquire the land.
Lordship.
That is important.
Lordship, I agree.
Affidavit after affidavit after affidavit, multiples of affidavit has been filed.
Lordship.
And yet we are in the same stage. There's no progress.
Lordship, I also kindly appreciate that the state has also communicated the decision of the state government, Lordship, to give free land to the authorities, Lordship.
You make a process with the state and let us see what action the state presents.
Lordship. It is not only this project, Lordship. The state has taken a decision for all the projects in the state of Nagaland, Lordship. There are more than 30 projects in the
It's your
state,
verbal
Lordship.
submission which this court cannot accept.
Lordship, we have filed affidavit, Lordship, enclosing the document that shows that the state has taken a decision to give free of cost, Lordship, for construction of the two-lane construction, Lordship, in the state. That decision has been enclosed, Lordship. In fact, the Chief Secretary of the state has communicated to us, Lordship.
If that is the case, Ms. Emti, you pay the compensation. You want to acquire land free of course and hand it to over to the central government? And you know that land holding in Nagaland is
Yes,
not like any other part of the country.
It's a very unique. But the thing is, the MOD and the energy official has to approach a step properly, because without the acquisition and requisition, the development cannot be, connectivity cannot be worked out. So this is a duty of the implementing agency to convince a concerned state that unless it is supports, we cannot just invoke a particular law in order to meet the developmental activities.
Yes, Mr. Ejimo.
My lords, there's a very unfortunate perception in the state as far as the authorities and government are concerned. They are under the impression that if land is to be taken for developmental purposes, if compensation is sought, then the project itself will not translate into on the ground in the state. That is a very wrong perception. Now, as far as the National Highways Act is concerned, there is a statutory obligation on the part of the Union of India to acquire the land. A letter written by the Chief Secretary of the government of Nagaland saying that in some meeting the government has decided that land will be given free of cost, that cannot override the statutory prescriptions. So in terms of the National Highways Act, there's a clear provision, a statutory obligation that the Union of India must pay compensation for the construction of the national highways. So all this argument about chief secretaries writing letters, etc., Your Lordship, they are meaningless. They hold no water. And as Your Lordship is aware, on the last occasion, I placed before Your Lordships the certain provisions, certain acts which were enforced even prior to the grant of statehood. National Highways Act was enforced even prior to the grant of statehood by virtue of the State of Nagaland Act 1962. National Highways Act are still applicable. resorting to the provisions of the National Highways Act, the NHRECL, the Ministry of Road Transport and Highways, they're declaring national highways everywhere. And they are ready to pay damage compensation, but they're not ready to pay land compensation. Where is the argument in this matter? So they must pay. Just because the state is ignorant, just because those in government unknowingly are trying to waive the rights of the citizens, the union cannot take advantage of that, lordships. That is where the real public interest lies. And that is why all these problems have arisen, your lordships. In the first place, if the Union of India had taken the right steps as prescribed by law, these problems would not have arisen. That is why, from the very first instance, your lordships, when I was brought into this case as the amicus curiae, I filed a bundle, different bundles about containing the relevant statutory provisions also, your lordships, and decisions by the Honorable Supreme Court as far as land acquisition and the national highways are concerned.
Let's see the National Highway Authorities Act. Let's-
Bundle A, my lord.
National Highway Authorities.
I have enclosed it in bundle A. Bundle A. Come straight to page 3 of bundle A. That's the National Highways Act.
Now, if we resort to this,
My lord.
we are going back to square one.
But, your lordships, with the greatest of respect, for the national highway itself, as proposed to be constructed, to begin the construction of the highway itself, this first step should have been completed first. It has not been done. But the fact of the matter is, your lordships, considering the grave situation as far as the road condition is concerned, this honorable court directed that the acquisition process should go on, and the road itself, on the existing road, should be made pliable so that people living within the state as well as the neighboring state do not suffer. So it was not as if the provisions of the National Highway Act was ignored, your lordships. No, the clear direction right from the first instance was go ahead with the acquisition process. In the meantime, construct on the existing road so that the road becomes pliable. That was the direction.
Say acquisition, when we speak about acquisition, the state is making a submission saying that actually the Union of India has never approached.
True, your lordships. And it is the duty of the Union of India, if I may take your lordships to the provisions of the National Highways Act.
Yes,
Section 3A, my lords,
yeah.
where the central government is satisfied that for a public purpose, any land is required for the building, maintenance, management, or operation of a national highway or part thereof, it may, by notification in the official gazette, declare its intention to acquire the land. It is the duty of the central government, your lordships. They have failed. Right from the beginning, the central government has failed. They have not discharged their statutory duties. They have failed in the constitutional obligation under Article 300A and taking advantage of the ignorance of the people of the state, if I may say so, my lords, in all humility. This is what is happening. And the entire process is prescribed under 3C, 3D, 3E. And not only that, lordships, in the state government, the Ministry of Road Transport and Highways, they have issued instructions as to how to go about declaring national highways, acquiring land, construction, etc., which your lordships will find on page 86 of this compilation. Page 86. A detailed procedure, step-by-step procedure of how to go about declaring national highways, acquiring land, and constructing the national highways. 28 December 2017. And this is issued by the Ministry of Road Transport and Highways. It is addressed to chief secretaries of all state governments, union territories, chairman of the National Highways Authority of India. A detailed procedure, a step-by-step procedure. But so far as the people of this state are concerned, both the Union of India as well as the state, as well as the NHIDCL, they're ignoring even their own instructions. So if I may, my lords, may I humbly submit, this is where the real interest lies. Public interest lies. The rights of the citizens of the state are being trampled upon in the name of providing a national highway. It is a lengthy document, Your Lordships. This instructions issued by the Ministry of Road Transport and Highways. And it contains each and every detail.
So
Of how-
without following these provisions of law, the work has started.
Yes, sir.
That is the issue.
Yes.
Now, whether we can direct the Union of India to actually go back and adapt this process.
That direction was there from the very first instance, Your Lordships.
That's it all.
The order,
Your Lordship,
Let us first see that all.
the first order, Your Lordships, when this Honorable Court took up the PIL, is order dated 2/3/22. 2/3/22. Then we can come to the page number. There's no page number, Your Lordships, but then to the portion which starts from, we had requested Mr. D.K. Banerjee. The paragraphs are not numbered, Your Lordships, but the paragraph which, in one of the internal paragraphs, we had requested Mr. D.K. Banerjee.
Yes.
We had requested Mr. D.K. Banerjee, the Senior Counsel for the NHIDCL, to take instruction as to what is going on this road, and today he has been kind enough to bring Mr. M.M. Mishra, the General Manager of the NHIDCL, PM Jakama, who is the man in charge of the portion of this highway. The General Manager has submitted that there is a project for upgrading this road, and work order has been issued to the contractor and his fortune groups. However, because of the problems the contractor faced due to non-availability of the right-of-way, the work could not proceed. If the state government on their part take the initiative and help the NHIDCL in settling the land issues along this portion of the highway, the work can start immediately. So this is a submission by the NHIDCL in the first instance, that the state government also should take the initiative and settle the land issues. Then the learned AG submits that if the NHIDCL can hand over all the copies of the correspondences or relevant documents regarding ROW, he will take up the issues with the concerned authorities and come back with a clear picture. So this is now the submission of the state. That notice be issued to the Secretary Ministry of Road Transport and Highways, MD and NHIDCL, Chief Secretary, Nagaland Commissioner, Nagaland Commissioner, Secretary Works and Housing, etc., etc., etc. So this is the first order, Your Lordships. Then the next order, 16/3/2022.
Nothing about the acquisition of land.
So the state as well as the NHIDCL said they would take instructions. That was the first order. Now come to the Lordships, please come to the order dated 16/3/22. Second paragraph. After hearing the learned counsels for the parties, it has come to light that no much progress has been made towards acquisition of the lands that are required for upgradation of the existing road. If one has to wait in resolving all the issues regarding to this, the working season for this year will be over and the people would have to suffer another year. It has been submitted by Mr. Leonard Additional AG that as far as construction and maintenance of the existing road is concerned, there is no problem whatsoever for the NHIDCL and the contractor to go ahead with the work. But if there is any problem, the state government is ready to resolve the issues and help them to continue with the work without any problem. Mr. Mishra submitted that a proposal has been submitted to the ED of NHIDCL Kohima for taking up the construction work on the existing road, and the ED has forwarded the same to the headquarters. He has also submitted that a discussion to that effect has also been taken up with the contractor and the authority engineer. Taking into consideration the deplorable condition of the road and the coming season, we direct the NHIDCL and the contractor to start the maintenance work of the road as per clause 10 of the contract agreement and to follow it up with the construction of the existing road immediately. In case the maintenance work is not taken up, NHIDCL shall resort to the clause 10.4.2 of the contract agreement. List the matter again on 24/3/2022. On the next date, the NHIDCL will furnish copies of the DPR.
Okay.
Then last portion of this sentence of this paragraph.
Any order passed
Yes, Your Lordship.
to complete the percentage of works on the available ROW?
This is one, Your Lordship.
Any order?
This is one, Your Lordship. This is where it starts. This is where it starts.
Which order?
This order, 16.3, Your Lordship. Paragraph which I was just reading it before, list the matter again on 24.3. We direct the NHIDCL and the contractor to start the maintenance work of the road as per clause 10 of the contract agreement and follow it up with the construction of the existing road immediately. With the existing road immediately. Then the last paragraph, Your Lordship, after the date. On the next date,
There was an undertaking given by the contractor that he will complete this part of the road to up to this percentage in the right of way. There was some order passed.
yes, Your Lordship. On the
Let's see
existing
that
road.
order. Let's see that order.
Your Lordship, on the land acquisition issue, if you may just finish this order, Your Lordship. On the land acquisition.
No. Let's see that order because land acquisition, I think there is no such order directing the center to acquire.
Oh, no, it is there, Your Lordship.
Let us see that order, the last order. I think we
Just
are
for a
not
minute,
good
Your
back.
Lordship. If you
Let
may
us
kindly
see
Your
that
Lordship.
order, Mr. Ejimobi, directing the contractor.
In the order dated 24/3/22.
24.
3/22. And if you can come to the paragraph where it says, keeping in view the
24,
submissions.
3, 22.
Yes.
Yes.
Please come to the paragraph which says, keeping in view the submissions. Have your lordships got that? Keeping in view the submissions of the learned councils and the parties involved.
No, just with keeping in. Yes.
Keeping in view the submissions of the learned councils and the parties involved, as stated above, we direct the contractor to go ahead with the maintenance of the road and complete the same within the time promised, and also to complete construction of the road within the existing parameters, that is, without further expansion, sojourning within a period of 4 months as promised.
Yes, Mr. Joshua, we go by this order to catch you.
It appears so, Lordship. But my lords,
This construction on the right of way has not been stayed by the Honorable Supreme Court.
the
So we catch
construction
you-
part, Lordship, it is going on, but the stay order, the operation of the stay order will,
That is time limit. The time limit given to you to complete.
yes, Lordship. So if that is stayed, then this very order also, Lordship, cannot be adjudicated if my lords may kindly consider that aspect.
So you don't work.
No, we're working, Lordship. We're working.
You are killing public interest. You are killing public interest. Very sorry. Very sorry. And you, NHIDCL, everyone is hand in glove. That is why we are not seeing the daylight of the work. And it is the people who are suffering. Yes, Mr. Moa, all projects undertaken by NHIDCL in Nagaland is ending up in litigation. Why? Something is very wrong somewhere.
Lordship,
All litigations I have seen.
if your Lordship may kindly peruse affidavit file on 12/4/2013, Lordship, 2023, Lordship, 12/4/2023.
Meaningless of taking this court to the affidavits when actually there is no progress in the
Lordship,
work.
this is the decision of the state government, Lordship. Chief Secretary's communication.
In fact, actually, you were actually supposed to follow the National Highway Act for acquiring the land. You have not done that. You have thrown the ball to the state government's table. See, it's a blame game. You're blaming the state not acquiring the land, and then state actually making a submission that it is you who should acquire the land. It's a blame game. It's a blame game where we don't see any constructive result. And all your projects, all NHIDCL projects
Lordship.
is landing up in litigation. There is something horrible somewhere.
If for a moment, if I may be allowed to take the Lordships to the affidavit filed on 12/4/2023, Lordship.
Yes, read.
Your Lordship, just one
It has
point.
just become meaningless to go through your
Lordship,
affidavits.
just one point on this issue of land acquisition. In the order dated 16/3/22, this Honorable Court has said that the land acquisition issues, the state respondents shall make all efforts to resolve the land acquisition issue at the earliest, but not beyond 4 weeks from today. So there is a positive direction there also in the first instance.
Now, the state is saying that actually they have not received any demand from the Union of India or NHIDCL for acquisition.
Your Lordship,
Tell us who is to be blamed ultimately.
Your Lordship, I will be allowed to submit a point. Here, the nature of the work, that is for existing road, for upgradation and restoration of the existing road.
That we know.
So we don't need to focus on the acquisition or requisition much because the work itself, that is for maintenance of the existing road. But
No,
but construction like Kohima, Dimapur. No.
No.
You see the work order issued by the.
It is for also widening of the existing road where actually land acquisition has to be made. And this is a national highway. If you are
Yeah,
to
national
acquire
highway.
land,
That
you
should
have to
have-
follow the National Highway Act.
Yes. If the appropriate authority have
No,
approached
not
the state
necessary
government,
submission. So we can neither go forward nor backward. We are in that position now.
As far as the acquisition issue is concerned, it is a statutory responsibility. It does not get waived, it does not stand extinguished because of efflux of time. It is still a live issue. And in fact, even the Supreme Court has noted that in Lordships. Because the land has not been made available. But that direction can still be issued. And that direction has always been issued by this Honorable Court. And yet, the Union of India as well as the state are not doing anything about it.
So, Mr. Moore, in terms of this Section 3 of the National Highway Act 1956, you take steps for acquiring the land.
Lordship.
And that step, you have to take steps with the state government
Lordship.
while initiating acquisition under this 3.
Lordship, my respect for submission if a direction may be issued by this Honorable Court, Lordship.
I think in the Supreme Court also, the case was not projected properly.
Probably, my lord.
Yes.
While reading of the order,
Right of way.
It appears so, my lord.
The order of the Honorable Supreme Court, as I understand, is the whole road.
Yes, ma'am.
Whereas actually in this order, which the Honorable Division Bench has passed,
Existing loan.
This was with regard to the existing loan. Anyhow, heard Mr. A. Jamuni, the learned amicus curiae, and Mr. Imti Imsong, the learned state counsel, and Mr. Muajamir, the learned counsel for
1, 2, and 8, Lordship.
1, 2, and 8. Mr. Joshua, the learned counsel for the
Respondent number 9, Lordship.
respondent number 9, and Mr.
Respondent number 10, my lord.
Santiago, the learned counsel for the respondent number 10. Today, when the matter is listed, Mr. Joshua places a copy of the order dated, this is 12/5,
Yes, Lordship.
12/5/2023, passed by the Honorable Supreme Court in SLP, Special Leave to Appeal, within brackets C numbers 99, this is the correct case, na? 9904
Yes, Lordship.
dash 9905 slash 2023,
My lord.
wherein, the Honorable Supreme Court has stayed clause D of the order dated 13/3/2023,
13/3/2023. Yes, Lord.
passed by this court. The clause D of the order dated 13/3/2023 reads as follows. Okay. The affidavit dated 31/5/2023, filed by the respondent number 10, has been perused, where the work completed is shown to be 33.33%. So also,
Respondent 10. My lord, in my affidavit, I have shown the completed work progress is 32.58, my lord. Physical progress. At page 3, my lord. Just below the column. The table that I have given, my lord.
okay. 32.58%. So also the affidavit filed by the respondent number 9
34.29, Lordships.
states that 34.29% of the work has been completed. Both the respondent number 9 and 10 shall on the next date fix file affidavit showing the progress of the work. File a detailed affidavit showing the progress of the work. At least though you have the order of the Supreme Court in your favor, I hope you will continue with the construction
Lordship,
for the betterment of the people.
Lordships.
What was the last line? On the existing ROW. On the existing ROW. On the remaining land required for the construction of the said work. Where is that petition? What is the respondent number of Union of India?
One.
The Union of India. That is the respondent number 1. Shall immediately take action for acquisition of the land as provided for under section 3A, as provided for under section 3A of the National Highways Act 1956.
Section 3 will do, Your Lordship, because.
Section
ABC
3,
Yes,
3A,
just 3.
Section
because
3.
It has many sections, yes.
Stop. All steps taken by the respondent number 1, that is the Union of India, shall be placed before this court. All steps taken by the respondent number 1 under section 3 of the National Highway Act 1956 shall be placed before this court by way of an affidavit on the next date fixed. Okay? I think you will have to, though we are actually very late now to give such direction without acquiring the land, I think the blame game will go on. So you will have to take steps. The state respondents shall render all assistance to the respondent number 1, that is the Union of India, while taking steps for acquiring the land to complete the project. Listed after 3 weeks. Okay.
Bless my lord.
Bless you, Lordship.
For admission, item number 4.
Yes.
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 Please, Lordship. Lordship, here the petitioner, he is a war charge chokidar on a fixed basis, and he was made to retire on 13/9/2019, and thereafter
13/9/2000.
yes, and
After serving for?
after serving for
35 years.
35 years, and then Your Lordship, after this, he approached this honorable court, and this honorable court by order dated 4/11/20 order
11/4/2020.
11/4/20, the page 82, Your Lordship.
Page 82.
Yes, 82 is the judgment and order,
Yes.
and the relevant page portion is at page 86. Para 6.
86.
Yes. Yes, I may be allowed to read, Your Lordship. I have considered the submission of both the learned counsels,
Yes.
keeping in view the facts and circumstances which have not been disputed, the pay of 380 ward charge employees, majority of whom were junior to the petitioner, were upgraded to scale of pay by the department. So, Your Lordship, this group of 380, these were given the upgradation after the retirement of the petitioner, not during the lifetime of the petitioner, Lordship. Leaving aside his case, in spite of the application submitted to respondent number 3. 2. The service of 195 persons who were all junior to the petitioner were regularized, and that too without meeting the requirements of the provision of the office memorandum referred to by learned advocate, government advocate. Though all this happened after the retirement of the
Miss, Madam,
yes, yes.
kindly give us 3 minutes.
No, sir.
Okay. Yes, ma'am.
So, Your Lordship, I may continue?
Yes.
I am of the view that the petitioner has been discriminated. Since the petitioner had served the department without any break for so many years, he should have been given the same benefit when he had asked for it, even without asking the state as a model employer and under a democratic form of government, and being a welfare state should have done it. Having not done so amounts to exploiting its own citizen for 35 years and releasing him empty-handed. The fact that his service was utilized till he completed 35 years of service, by which any person serving under the government of Nagaland is to retire, shows that his service was not only required but fully utilized. If a person's service is required and utilized, he should have been given what he deserved. 7. It has been submitted by the Learned Council for the petitioner that the petitioner, when he retires, enjoyed only rupees 3,450 per month as pay. It is difficult to imagine how he would have struggled all his life to look after his family members. After having led such a life, to let him go empty-handed cannot be reasonable. Slavery and forced labor are things of the past, but it appears that for some people they still suffer from such practices. Therefore, in similar cases such and such, this court on 24/3/2022 had allowed the prayer of the persons who are similarly situated as the petitioner and directed the state government to consider regularization of the services for pension and pensionary benefit. Taking in view the order passed in those 9 writ petitions and the order of the Honorable Supreme Court given above, this court is of the view that the case of the petitioner praying for regularization of his service so that he may enjoy pension and pensionary benefit is a legitimate prayer. 9. In view of all that has been stated above, the writ petition is hereby disposed of with a direction that the respondent should regularize the petitioner's service within a period of 4 months from the date of receipt of a copy of this order so that he will at least enjoy pension and pensionary benefit after
Yes.
all those years. So, Your Lordship, this learned single judge has directed the state respondent to regularize the service of the ward charge fixed employee. So here, Your Lordship, in Nagaland, the state government, we have 2 schemes for regularization of the ward charge employees. Lordship, I may allow to take you to page 45.
Yes.
Yes, that is the OM dated 7th March 2015. So this OM says that a ward charge employee should be on a scale of pay, and he should completed 30 years as on 1/1/2015.
What is the yardstick adopted by the government
Yes.
to pay scale of pay and regularize the service of fixed pay employees?
So
What is
the
the
Lord-
yardstick laid by the government?
Lordship, the ward charge employees, they are governed by the ward charge employees, they are governed by the Nagaland Ward Charge and Casual Employees Regulation Act 2001. So under this act, section 3, it says for constitution of a
No,
committee.
I am not on that. I am on what is the yardstick adopted by the state government.
Yes.
Because the state government, like after a person is appointed on fixed pay,
Yes.
the state government pays him scale. The
Yes.
state government regularizes service.
Yes.
This is done within a specific group of employees, whereas a group of employees is left out.
Lordship,
So what criteria is adopted
For
to
that-
make this classification?
Yes, for that one, Lordship, I may be allowed to take you to page 55. This is the administrative approval, Your Lordship. But just because Your Lordship may take into consideration that just because a petitioner may be discriminated or he similarly situated person has been given scale of pay, which is not proper in law. Petitioner cannot claim, though he may be discriminated, petitioner cannot claim the same benefit which was illegal,
You cannot take the
illegally
concept
granted
of
to that.
negative equality in
Yes.
such cases. You cannot take the concept of negative equality.
So, Your Lordship, my prayer here is that
This is not discrimination. This is exploitation.
no, it's not an
It
exploitation,
is
Your Lordship.
exploitation. You're using the service of some person for 35 years, and one fine day when he becomes old, unable to give his service because of retirement, you say you go empty-handed. Is it not exploitation?
No, Your Lordship, because see, the word just regularization, Your Lordship, they are not holding a sanction post. So when a person is not holding a sanction post, whether a person can be regularized. And a person can be regularized
Madam,
only when he comes under the policy of the government.
All these submissions would have been very good and very attractive if only you had adopted a proper procedure of appointing fixed pay, giving them scale of pay, regularizing them. If there was certain criteria, your submission would have been attractive. Now the state government, as we see, is acting haphazardly in favor of some. Even after within 2-3 years, they give them scale of pay, they regularize their service. For some, the state government retained them for 35 years on fixed pay.
So, Your Lordship,
And one fine day, tell this
for the
employees to
fixed
go.
pay, Lordship, for the fixed pay also we have a policy to be regularized them.
Your policy is not followed.
But we are following.
Your
but
policy is not being followed.
we
That
are
is what
following
have
the
seen.
policy. Lordship, here, if the petitioner is the senior most, then he can be accommodated. But at the
You-
time
in
of
your-
his
in your
regularization,
petition.
Your Lordship,
In your appeal,
yes, yes.
have you stated that this criteria is followed to give this fixed pay employee scale pay and regularization service, and this class of fixed pay will not be entitled to scale of pay and regularization service?
Lord-
Have you mentioned that?
Lordship, in my grounds also, I have stated some of what Your Lordship is asking. Plus, Your Lordship, we have a two policy. One is for the fixed pay and one is for the scale
You
of
have
pay.
no case. You
So-
have no case.
So, Your Lordship, the petitioner at the time of his regularization,
case.
at the time of his retirement, he stays as serial number 9. So, if this Lordship, if this single judge is to be followed, Your Lordship, then petitioner stands at serial number 9. Those persons who are before him has not been regularized. So, he will be superseding all those people,
What
Your
about his
Lordship.
juniors who have been granted scale of pay?
Your Lordship,
And who
that's
have been,
why
uh,
it
regularized?
is in the administrative approval. Petitioner has never challenged that administrative approval.
Not the question of challenging that administrative approval. There should be fairness in your action. There should be
Lordship,
fairness in your action.
yes, Your Lordship. The petitioner has never challenged that administrative approval, giving granting scale of pay to the persons who are in service. Those persons are in service, but the petitioner has already been retired, Your Lordship.
Your submission is very attractive, but it is not supported by me.
Okay. Lordship, if that is the case, then
Yes.
yes, Lordship, yes.
Yes, Mr. Sanku.
My lord, the administrative approval, it speaks, it regards to, it confines itself to a group of petitioners in WBC 228K/2018, by which a direction was given by this honorable court to dispose the representations filed by those petitioners, my lord, and to consider their representation within a specific period. Now, administrative approval has been given, my lord, by the state government, granting regularization to those group of petitioners, my lord. And in that case, my lord, I am not a party, I am not a petitioner, I am not a respondent also. And as such, my lord, I cannot, in short, I am not privy to it, my lord. Secondly, my lord, the learned single judge has also passed the judgment dated 11/4/2022, my lord, based on the, it has been quoted in paragraph 4, the Supreme Court decision passed in Gauhati case, my lord. I am allowed to read, my lord. Paragraph 4. Page 85, my lord.
Your affidavit?
No, the writ appeal. In the writ appeal, it has been annexed.
Okay. Page?
Page 85, my lord. Paragraph 4 of the judgment and order passed by the learned single judge, my lord. Page 85, my lord.
Yes.
4.
This state of Gujarat?
Yes, my lord.
Yes.
Lordship is aware of this, my lord. And my lord, the submissions made by the learned additional Advocate General, my lord, is on the date of the Honorable Supreme Court decision passed in Branson, my lord. Lordship is
Miss
well aware.
Sokre, V. Sokre.
Lordship.
How do you get over this para 4? How does the state government overcome this para 4?
Lordship, nowhere in the Supreme Court judgment it says that the state of Gujarat has a policy to regularize such person.
Okay.
But in our case, we have the regularization person. I have a Supreme Court judgment which clearly says that to regularize a person, it has to be according to the regularization policy of the state government.
Okay, that is
So
not-
as per the state government policy, petitioner is not entitled to be regularized.
Why?
Yes, because he is on fixed pay and he is not the senior most. At the
Now-
time of his retirement, he stands as serial number 9, Lordship. If he is, at the time of his retirement, if he stands as serial number 1, and if there is a vacancy, then he can be regularized. And even the Supreme Court initially
Now
also. Yes,
justify your submission.
yes,
Justify your submission
yes.
with the actions of the government where persons junior to the petitioner on fixed pay has been paid scale of pay and regularized in service.
Lordship.
You justified that
Lordship,
action of the state
yes,
government?
Yes, here in my grounds, I have stated, Lordship, at page 12, ground number 6. Page 12,
read.
ground number 6. That the learned single judge had erroneously came to the conclusion that the pay of 380 were charge employees, majority of whom were junior to the petitioners, were upgraded to scale of pay by the department, leaving aside his case in spite of the application submitted to the respondent number 3. The service of 195 persons who were all junior to the petitioner were regularized, and that too without meeting the requirement of the provision of the office memorandum referred to by the learned government advocate, though all this happened after the retirement of the petitioner. I am of the view that the petitioner has been discriminated. Such observation is not founded on well principle of law, as upgradation of fixed pay to scale of pay was given after the retirement of the writ petitioner, and those were charged employees who are similarly situated as that of the petitioner who had retired before the office letter dated 23/7/2020 were not given scale of pay. Therefore, the writ petitioner is not alone excluded. The 195 persons whose service were regularized came within the zone of word charge regularization, as these persons were regularized prior to writ petitioner's retirement and after writ petitioner's retirement. As such, the writ petitioner cannot take this person as similarly situated with him. So, Your Lordship, the petitioner is not alone excluded, Your Lordship. And if at all the petitioner is aggrieved with that administrative approval, he could have challenged that one, but he never challenged the administrative approval. And the other person, 195, those are the persons who come within the category for regularization. So those persons were regularized before the petitioner got retirement and after the petitioner got retirement,
These
Lordship.
persons were regularized because they were in a scale of pay.
Yeah. So,
Correct.
yes.
Just listen.
Yes, Lordship.
Just listen. They were in a scale of pay, that's why they were regularized. Now this court comes down to the issue, why when all these petitioners and all this similarly circumstanced person, they were on a fixed pay, on what ground, by applying what yardstick, you have granted scale of pay to this employee and you have denied the scale of pay to the other person? You just satisfy this court on that issue, then we'll allow your appeal.
Lordship, on that issue,
That is where the cracks lie.
exactly, Lordship.
That is
the-
where the discrimination lies.
yes,
That
exactly.
is where the exploitation lies.
But Your Lordship, see, just because somebody scale of pay, when a person is
Okay, Ms. Sokre,
yes.
this will be the last day of this bench. So maybe till the next date you can breathe. We will list it immediately next division bench. But you come with the reasons on that issue which this court has raised. You come with reasons because actually in many cases we are seeing that actually there is actually no criteria adopted by the state government to give scale of pay to some fixed pay employees and to deny others. See, that is where the whole issue has arisen. That is why we have so many cases of this nature.
380 employees, my lord.
And
have
and
been
and and,
employed
and,
at the
and
private scale of
actually
pay, who are all junior to me.
without any proper norms, this actually gives the state to exploit. This gives the right to the state to pick and choose. This is where the problem lies. So you come prepared on that ground only. On that ground, if you can satisfy this court, maybe we will allow your appeal. But if not, I think
My lord, in the meantime, I may be allowed to file an affidavit, my lord.
regarding
On the writ appeal, my lord. I have filed my affidavit in opposition in the IA, my lord. But
no,
I will-
you are you going to introduce new grounds?
No, my lord. No, my lord.
Then
But on the grounds that the appellant has raised, my lord, I may be allowed to file an affidavit in opposition in the writ appeal, my lord.
the grounds, I think these were all discussed before the learned single judge.
My lord, my lord, my lord.
Correct.
Yes, my lord.
So on the, I think while actually adjudicating the matter on the basis of the records, I think
My lord, my
you
lord,
will have all the opportunity.
my lord, lordship. But my lord, I want to make certain tables and columns, my lord, so that those junior employees who were regularized and awarded scale of pay will be placed before the court.
Heard MSB Sokre, the learned additional advocate general Nagaland for the state appellants, and Mr. Santi Amar, the learned counsel for all the respondents,
The sole respondent, my lord.
for the sole respondents. This is the case again.
Next week, my lord.
Next week we will not be, okay, next week we will be having division bench, but I doubt. Okay, listed on 8, that is Thursday, okay?
My lord.
8th of July.
8th of June,
Because I think we will be having division bench only on 8.
my lord.
Listed on 8, 5, 8, 6, 2023. In the meantime, Mr. Sentianger, the learned counsel for the respondent, is allowed to file affidavit bringing certain clarifications before this court. Listed accordingly.
Deeply obliged, my lord.
For orders, item number 6 and 7.
May I please, Lordship?
Yes.
Lordship, by order dated 12/4/2022, mentioned in the civil revision petition. Lordship, this is a transferred case from the Appraisal bench.
Oh,
So by
which order?
By order dated
Mr. Elima, which order?
12/4/2023, passed
Yes.
in civil revision 5.
Let's just. Civil revision?
5.
5, yes.
The petitioners were directed to take steps upon the respondent number 4 and 5. Lordship, we have taken the steps accordingly. In now the respondent number 4 and 5 are represented by my two learned friends. Yeah, yeah.
This is a transferred case.
Yes, Lordship.
This is a transferred case. So let us see the petition, let us see who are the respondents.
Pang Sebastian Zambo, respondent number 4, and the village council Kohima.
Okay. Yes. Who is for the, boy, Dima, you are for the
I'm
petitioner.
for the petitioner.
And yes, ma'am, you are
Lordship, I'm for respondent number 4.
for, and who is for 5?
Lordship, I'm representing respondent
Respondent
number
number 5. Who is 1, 2, and 3 state?
Boa petitioner's appearance.
Yes, yes.
For more injury.
Okay, okay. Have you filed your affidavits?
Yes, Your Worship.
Respondents, all the respondents have filed. You have also filed your affidavit? State has also filed.
I don't know, my lord.
Right, they filed.
Are you sure? Okay.
Worship, the mirror was hurt on the last occasion. Worship, here the issue is
By this court?
no, Worship, by Justice Chaudhary, Arundip Chaudhary.
Okay.
He has heard the matter finally, and he has differed with the judgment passed by Justice Chaudhary. According to the matter was referred to the latter page before the chief.
Okay.
Yet the Honorable Chief Justice yes, please before the division bench now. After it has been transferred.
So what was the conflicting judgments?
Worship, the conflicting judgment was Justice Chaudhary passed a judgment that under Rule 31 of the Rules for Administration of Justice in Nagaland,
Okay.
an appeal can be preferred to the district judge against the order passed by the village authority.
An appeal can be preferred to the district judge against the order passed by the village authority.
That was a judgment passed by the Justice Chaudhary.
Okay.
Whereas Justice Arundip Chaudhary, he deferred to that judgment.
Okay.
And explained
And what was the ground of to
the main,
differentiate?
the main ground is in Nagaland, there's like a civil court act.
Correct.
Worship, the administration of justice, civil and criminal justice has been administered under 1937 rules. But now, due to subsequent worship, after the separation of executive from the judiciary,
So because of these two conflicting judgments, this case could not be processed.
this could not be.
So what is your case now?
Worship, now, since the party is also represented,
Yes, yes. No, I just want to have a gist.
a case will be fixed.
Yes. What is your case, but?
Worship, my case is this.
Uh,
Worship, after the separation of judiciary from the executive,
uh,
released by a notification, the assistant to deputy commissioner and the deputy commissioner, you were placed under the control of the high court. Which by that order, that order is become the page number 16 in the civil revision 5.
in the
Yeah, civil revision 5.
civil revision. In page
Page 60. 60.
60.
60.
60. Yes.
My case was case one. Actually, finally,
Yes.
this is a notification dated 22nd May 2008. In excess of power covered by Article 309 of the Constitution of India, which Clause 3 of Channel E of the Nagaland Civil Service Code Clause 6. The Governor of Nagaland is pleased to change the nomenclature and redesignate the following existing judicial courts in the state. Which is by this notification, the earlier DC judicial,
Ah,
its nomenclature has been changed to district and state judge.
correct.
Only the nomenclature has been changed,
Correct.
not the fresh appointment.
Yes.
So my condition is how by this notification have been placed under the control of the High Court.
Correct.
Since only the nomenclature has been changed, not a fresh appointment. The appeal can be preferred. Still, the appeal can be preferred for a that's my condition.
Against the order passed by the village authority, that is village council. Your contention is that it can be
Still
appealed before
the district judge.
district judge.
Since under Rule 31. Since that is permissible under Rule 31 of the 1937. It's not a fresh appointment.
No, but Rule 31 does not speak about this DC judicial, ADC judicial.
Under Rule 31, it says that
Yes, 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 please.
Rule 31 says like this: an appeal shall lie from the decision of the Mazadar, Konpura, Chief Hitman of Hills, Oposhis, or other duly recognized village authority to the tribal court whenever considered or otherwise. No, we don't have a tribal court.
To the tribal court, we don't have.
And so to the deputy commissioner or his assistant.
to the commissioner
deputy commissioner or his assistant.
or his assistant.
So that
Or his assistant. So
here the deputy commissioner judicial, as per this rule 31. And so it lies under
no, but when actually this judicial magistrates are no more assistant to DC, they are no more.
after the
They are no
after
more.
the separation. No
So the state government has designated certain officers to be assistant to DC. So why not the appeal before this assistant to DC or to DC?
in order to solve all this issue, by this notification of 22nd May 2008, it will not solve this issue unless a state government frame a civil court.
No, but actually you see, now DC judicial, they are district and session judge.
By this notification.
Judicial magistrates, they are junior, the judicial
Senior-
magistrates first
senior-
class, they
senior
continue to
district
remain.
judge.
Correct. They are civil judge now. So when actually by this notification, the nomenclature, which was then used by judicial officers, has been done away with. And the as per the Nagaland code, the appeal can be preferred before the deputy commissioner or his assistants. And there are officers who has been designated as assistant to deputy commissioner by the government. Why not before those officers? Why you are insisting that this officer should take up this case?
Under the 137 rules, if we go as per the definition of the deputy commissioners,
A deputy commissioner also includes a deputy commissioner judicial. But now the fact remains that deputy commissioner with this notification, there is no more deputy commissioner
No more.
judicial. No more.
should be deteriorating.
So why you are actually like insisting that this your
But Lordship,
judgment decision by the village council should be
if that
before
is the case,
district and session judge?
If that is the case, it is an appeal passed by the village authority. Now where will it go? Just no forum.
No, under 31, you have the avenues.
Deputy commissioner's assistant.
Yes.
Now the deputy commissioner assistant, now they have been.
Now, deputy commissioner means the deputy commissioner of the district. Assistant to deputy commissioner means those officers appointed by the government of Nagaland as assistant to DC. You can go before them under 31. See, the issue is that you are only trying to complicate the issue.
It will be fixed for.
Okay, we'll fix.
It will hearings recording. And Lordship, unless a civil court, Nagaland State Government frame a civil court act, this issue will be difficult to.
No, it's not difficult. It's not difficult. It will be decided by the higher forum if any appeal is made. But for this court, I think this issue is not so complicated. Okay. On the prayer of the Learned Council for the parties listed for admission hearing on when?
After to the convenience of my two learned friends, since they'll be coming from Timor.
Yes, ma'am. You give your convenient time, but before 1 month.
Yes, within a period of 3 weeks. Can we try on 21st?
Yes.
21st June?
21st June. Listed for admission hearing on 21/6/2023. Okay.
For orders, item number 8.
Item number
8.
7.
8 or 7?
7.
Ima?
7. 7.
7. There's a 6 and 7.
Oh, so 6 and 7 are analogous. Also.
Analogous.
Item 8.
Yes. What is the matter?
Lordship here by.
Jail appeal.
Yes, jail appeal.
Yes.
Appellant has been convicted under POSCO Act. Lordship, by order date 10/5/2023, the yield share was called for. Lordship, I was informed that the yield share has come.
Yes. Will paper book be necessary?
Exactly, Lordship. registry may be directed to prepare the paper book, and the appellant also may be given the liberty to submit the list of documents.
But Mr. Oh, is it? We are told that the notice upon R2.
Worship R2, it will not be necessary. Since
Who is R2?
he's a victim.
He is the victim. He is the most
No,
important person in this case.
Worship,
As per the latest decision of the Supreme Court, he is the most important person.
Worship, the prison petition are also of a sumutu complaint.
No. But I think we need this victim.
Okay, Worship.
Yes. And who represents the victim?
Mother.
Mother. He is the most important person. What was that judgment?
Worship, you have doing something.
What was the judgment where actually the Supreme Court has held that actually the participation of the victim, the complainant and the victim in the case is essential? What is that?
We have served a notice by registered post. However,
The bit.
since Worship, the notice sent by registered post has not been affected.
See, this is a POXO case.
Also, this.
You are not supposed to reveal the name of the victim. You are not supposed. You can just use Mr. X, Mr. Y, Miss X, Miss Y, represented by her mother, Mrs. So-and-so.
You know that no court proceedings. Worship, the name is mentioned. Worship, the service upon the respondent number 2 by registered post is not affected. So, Worship, I mean, we are allowed to dig free escapes through the OC of the concerned police station.
OC of which concerned police station? Which police station?
Sure, I'll find. It's an Oman police station.
Doing some?
Oman police station.
Doing some woman.
It arises of your case number 4 of 2019.
Mr. Limawang, the learned counsel for the appellant, shall take steps for service of notice upon the respondent number 2 by registered post with AD as well as by
Worship, by registered post with AT, hereof, OC, the Kasol police station. I think that is so. Worship,
will it be proper?
Worship, C is filed by the High Court Legal Services Authority for it me to go up for service of notice.
So what was, ma'am, what was the
In the accused is under custody.
with AD through the officer in charge of Tuengsang Women Police Station, Tuengsang Women Police Station, Pumat Tuengsang Nagalit. The steps for service of notice shall be taken within a period of 3 days from today. Stop. Upon service of notice to the respondent number 2, the officer in charge, Women Police Station, Tuengsang, shall file a report. Stop. Registry to take steps. Listed after receiving the report from the officer in charge, Woman Police Station, Princetown. Okay.
So the paper book can be published only after that.
So let us first see
You
the
may also like to
description.
submit your list of books, list of documents. Right.
For hearing, item number 9.
Yes, brother says that we will not be meeting for at least 3 months, and rightly so.
Otherwise, Lordship has given sufficient time to hear. We thought that we'll be able to finish today.
We're supposed to file your affidavit.
I have filed, Your Lordship. I have filed.
What is this? So let us see your affidavit.
Yes, Your Lordship. I have annexed all the relevant documents regarding the distribution of work.
Your affidavit is 29 May.
Yes, Your Lordship.
29 May.
Yes, 29 May. It's bigger than the rate petition, Your Lordship. Annexure 1, page 7, it starts from, this is the Nagaland Rules of Executive Business, Your Lordship. Page 7. The relevant page is page 44, all the departments, assignments are there. So the relevant page is page, it starts from page 43, Your Lordship. This is with regard to labor, employment, skill development, and entrepreneurship department. So with regard to labor, it is a separate department. A. So at page
What about skill?
page, yes, Your Lordship.
43, what about skill?
In the next paragraph, page 44, it starts from B. Employment is at B, skill development at C and B. So employment, about 4 assignments, 4.
Implementation and enforcement of compulsory notification of vacancies. Implementation and enforcement of compulsory notification of vacancies Act 1959. Compulsory notification of vacancy. of employment market information. And where's your craftsman?
Skill development, C. Skill development and entrepreneurship. It comes under those two, C and D.
So you perform different works.
Different works, and your lordship will clearly see the amount of work to be executed is more with regard to the skill development and entrepreneurship, your lordship.
Let us not go by the numbers.
Your lordship, but your lordship will see implementation and enforcement of compulsory notification of vacancies under the CNV Act. It is for the employment wing to do. Collection of employment market only. And then vocational guidance and employment counseling. And placement of persons with disability only. This is where they are confined. They don't go beyond that. And with regard to the craftsman training wing, implementation of craftsman training schemes, policies and procedures, your lordship. All these are to be done by the craftsman training wing. State Council for Vocational Training advise the state government on issues related to vocational training and skill development policies and procedures. So the government is to be advised by the training wing, not by the employment wing. Trade testing and certification, apprenticeship, implement and enforce the Apprenticeship Act of 1961 and as amended from time to time. All matters pertaining to skill development in the state. All matters pertaining to entrepreneurship development in the state. So, government is to be advised only by the training wing in this regard, since this is technical in nature. Now, your lordship, Annexure 2. Annexure 2 is the annual administrative report, which is at page 59, starts from page 59. Annexure 2. It is, all the activities are in consonance only with the rules of executive business. If your lordship may go to the content.
This were never a part of your petition.
No, your lordship required that the nature of works performed by the two wings should be.
Mr. Tom Cook?
Yes,
I
your
think we
lordship.
will not be able to complete all this today.
Your lordship. I leave it to your lordship.
think we will be taking a chance in the next division bench.
Your Lordship.
Because after hearing you on all this and after hearing, if you want to hear Mr. Azo, then the government advocate, then it may not be possible for us. So we'll list it on the next division bench.
Your Lordship.
Release from Powtat. Listed.
7, my lord.
7, there will be no division bench. You can take a chance on 8. We will have a senior judge.
My lord. Yes. That will be very kind of my lord.
Listed on 8/6/2023.
Much obliged.
Then in the meantime, Mr. Azo,
My lord.
if you want to file any,
Nothing is required, my lord.
nothing required.
In fact, this case basically to be determined on the question of law.
It has the law. The question of law has to be determined.
Yes.
But to go into the question of law, we need to see what are the facts.
My lord.
Yes. Your Lordship.
I'm aware of that, my lord.
So you will not be filing any.
I'll not. I choose not to file.
But these are all based on records.
Your Lordship.
Much obliged.
Yes, let us see what they have.
Please, Your Lordships.
Yes, Mr.
Lordships,
CT.
I would like to make an unusual prayer.
Yes, what is that unusual?
I
You
think
are always
19
unusual.
Today is item 19 is fixed for hearing, and today being the last working day of this bench.
Item.
Item 19, 19. It's not likely to be complete today.
Yes.
And incidentally, in the court number 2, my Lord Justice Galita has heard one matter which is kept part heard, and we have been warned that it should be completed by Thursday.
Oh.
My learned friend, Mr. R. Iralo, who is the same counsel here,
Uh-huh.
he has taken 2 days and he has concluded his submission.
Okay.
And I'm so eager to start my submissions today.
Okay.
So, in view of these
So
lordships, this matter may be taken up in the next TV.
before my brother, the matter is connected with this 19.
Yes.
No,
No,
different matter.
not matter is not connected. In the single pinch,
Okay.
another matter, civil matter, which is pending for the last 48 years.
48 years. Okay. Okay. So when can we have this 19?
Any day, lordship.
So we show the presence of all the councils
I will inform them, lordship.
on the prayer of the learned council for the parties listed on,
Next TV or whenever it will be complete.
listed after,
Start after 2 weeks.
listed after 2 weeks. Okay. Okay, 19 got it.
May I please, Lordship?
Yes.
My Lord, item number 10 to 18 is listed for hearing today.
10 to
18, analogous matter. Hearing item number 10 to 18.
okay.
I think today it won't be possible to take
10
up the
to
matters.
18.
Yes, my Lord.
Okay. Who is for the other side? Where's Mr. Likase? I didn't see him today.
He was here. Whether it will be possible to take up today or not, my Lord. After break.
So this is because actually this will be the last day for this bench to sit. That is a problem we are having. Why, I think, let us fix this matter on 8,
8,
8 June.
8, I may be out of station on 8.
Okay, because
After-
first, like, 6, was, 5, 6, 7. As per the roster, they'll be on a single bench. And 8, 9.
14?
Yes, Mr. Nikase,
Yes, my lord.
we'll have to list this matter on 14th.
Yes.
Okay.
Sorry.
List the matter again on 14/6/2023. Okay?
Okay. Much obliged.
Yes.
Item 22.
Item?
22.
Ah. Yes.
And the respondent, it is state appeal.
Then who is for the state?
Supri.
Yes.
Can it be fixed on 8, my lord?
8.
My lord.
Okay.
Okay, my
You
lord.
tell Sokri. On the prayer of the learned counsel for the parties, listed on 8/6/2023.
Fix, my lord.
As a fixed item.
My lord.
Yes, as a
Much
fixed item.
Much obliged.
Yes.